Hello everyone, this is Mark Blakely and this is my Module 13 presentation on tort liability. So first let's establish what tort liability is. From what I understand, it is any kind of civil wrong or wrongful act that results in injury. That civil wrong can be intentional, meaning there's intent to knowingly cause harm, or it can be unintentional, or what's also known as negligence, in which a person fails to carry out or is careless in their duty. That type of negligence or type of tort is what we see most often in the school setting. Breaking down these liabilities even further, we can see that intentional would be things like assault, battery, defamation, false imprisonment, trespassing on personal property. So things that are intentional and obviously wrong. With negligence, you have to prove standard of care, meaning as an educator, you have to provide care similar to what a parent would provide in the same situation. Breach of duty is saying that you are not providing that standard of care. Proximity is saying that something happened because of something you did or did not do. And lastly, there has to be some kind of injury that occurred. All right, so let's look at our first case of Johnson Johnson versus the School District of Millard. In 1993, there was a first grade student who was in music class where the teacher had taught the student the game of London Bridge, where the students connected their arms and rocked the student back and forth between their arms. Johnson was that student who was being rocked back and forth by the other students rather hard and ended up being thrown accidentally into a bookshelf and sustained a cut above his eye. Johnson's mother then sued the school district for negligence because she said the teacher had her back turned when the event occurred. In this case, the court ruled in favor of Johnson based on the fact that the teacher did not provide enough supervision while the students practiced the game. If this happened in my school, I'm guessing there would be some kind of disciplinary action. I don't necessarily think that there would be a dismissal, but I do think some sort of write-up would be placed in the teacher's file and there would be some other kind of formal reprimand. I also think anytime a situation like this occurs, the administrators are going to evaluate our policies and talk with staff about things we as educators need to be doing to keep our students safe and evaluate any activities we do with our students that could pose a danger. For proactive measures, I think there needs to be a clearly established supervision expectations, making sure teachers know that they have to kind of keep that eagle eye on their students at all times, especially when we're allowing these types of activities to take place in our classroom. And also educating teachers on the laws for which they're liable to their students for. I think they need to know about these laws and hear about previous court rulings, not as a scare tactic, but just a way of bringing awareness to the seriousness of their care for their students. As far as the benefits of professional ethics, again, making sure teachers are being vigilant and keeping an eye on their class is going to minimize any negligence or harm to your students. All right, in the second case of Mosley versus the Portland School District, 15-year-old Cressetta Mosley became involved in a fight with another student during their lunch period. The other student produced a box-cutting knife and stabbed Mosley several times. Though there was security personnel on campus, they were not near the place of the altercation. So Mosley ended up receiving permanent scarring to her face and her chest. However, the court ruled in favor of the school district because they had already taken necessary steps to protect their students with security personnel, which that then allowed immunity to them under the Oregon's discretionary immunity statute. Looking at the reactive measures of my district, I'm unsure how they would respond to the situation. I teach in a small district, so security measures we already have in place are already less than adequate, in my opinion. With that being said, if this incident did occur, I think administration would need to consider upgrading our security policies in each of our buildings. Right now, our support staff are the ones who cover lunchroom supervision. So I would foresee some kind of training on how to deal with these situations as a must for those supervisors. I think districts could also be proactive in this type of situation by providing security personnel in those school buildings. I know it's difficult to fund those types of things with the limited funding that schools have, but I think that goes a long way in being proactive. I also think that having those personnel in the lunch periods is detriment because that's a less structured environment with many students, and that's going to be an area where altercations like these could happen. I also think that the local law enforcement could visit our school classrooms, and they could talk about situations like this and the importance of school safety and the importance of not bringing weapons into schools. If it were feasible, then schools could purchase metal detectors and security cameras to try and help deter situations that are similar to this case. As far as professional ethics in this case, I think it's important to, again, make sure supervision of students is carried out diligently to help eliminate any chance of negligence. In the next case, Flanagan versus Canton Central School District, fifth grade student Brendan Flanagan was in a locker room following a rowdy gym class session. While in the locker room, Flanagan was pushed from behind by another student and hit his head and chest on a locker and a nearby bench. Flanagan received injury great enough that he needed an emergency procedure. Flanagan's mother sued the school for the negligence based on the fact that the gym teacher was not in the locker room at the time that this incident occurred. He was in the gym talking to another student. The court favored in Flanagan's direction based on the fact that the teacher knew there was an elevated risk of an incident because the class was already not listening to the directions and was kind of out of control before the incident in the locker room, and that gym teacher did not supervise the locker room. I do know that the school questioned whether the teacher could have reasonably anticipated the pushing incident and whether it could be even proven that the injury occurred because there was a lack of supervision. Nonetheless, there was an apparent lack of supervision, parent negligence in this case, and the court saw that. This probably wouldn't happen in the elementary school that I teach at just because students don't go into the locker room to change during gym. But I could easily see this happening in our middle or high school. I'm not sure what the gym teachers do as far as their supervision with the students when they're changing, but I'm willing to guess that they're probably not always present during those times. So I think it's possible that a case like this could happen in my school. So that's why it's important to make sure that those teachers are always supervising in the locker rooms, because this case obviously does show negligence. So I think a reactive measure, my school would probably dismiss the teacher or some other kind of harsh reprimand if this were the teacher in my district. Our school already has expressed supervision of the students in the locker rooms at all times. So it would be pretty difficult to defend yourself if you're not doing that. For proactive measures, supervision again is key here. You have to supervise all the kids in all the places at all times, making sure that the kids know to keep their hands off each other and holding kids accountable when they break those rules. Again, the professional ethics that benefit for this are constant supervision, protecting the students, protecting ourselves, protecting the school district. Ultimately, we're just trying to keep anyone from getting injured, and the locker room is a place that could happen if there aren't any teachers around. Moving on to the fourth case, Sidwell versus Griggsville Community School District. Student Bryce Sidwell was injured on the school playground after falling in a rut. His mother sued the school, claiming that the school district was negligent for, one, allowing the rut to form and deepen in the first place, two, failing to fill the rut, and three, allowing the student to play on the playground where the rut was. The court found that the teacher had immunity under the Illinois school code, but the district did not, and therefore was liable for the rut. I think this was a tricky case, although the student was under the direct supervision of the teacher. The teacher is not the one that is responsible for maintaining the playground. The reactive measure in my district, if this happened at my school, would most likely be some type of disciplinary action for those who knew about the rut, especially if it had been known for a prolonged amount of time. I think the district would take measures to express the need that we need to communicate any kind of dangerous facility issues. In my district, we do have an electronic submission for our maintenance request, so it would be documented when the issue was first noticed. As far as proactive measures, I think it's necessary for the maintenance personnel to make routine checks on the grounds, especially in the areas like playgrounds where the students are most likely to participate in activities that could lead to injury. It's also important for teachers and staff to understand that their supervision of students also includes making sure that the environment the kids are in is safe. I think this is an incident this case is an incident where it could have easily been avoided had the teacher just kept the student away from the rut in the playground in the first place. The benefits of professional ethics, again, come down to if there is a close supervision of the students in the area, then events like this are going to be unlikely to happen. The last case I'm going to look at is a bit of a unique case compared to the others. The parents of Michael Pauly had been having a custody battle beginning in 1989, and as it stood when this particular incident happened, both parents had joint custody, but only the father had primary physical custody. The incident occurred in December of 1994. The mother brought an officer and custody documentation to school stating that she would be taking her son for a Christmas vacation, which was part of the custody agreement. However, it was a few days before the actual Christmas break began at the school. The principal called the father, who refused to let the mother take the student, but after looking at the documentation and speaking with a police officer at the school, the principal made the judgment to allow the mother to take her son. She was supposed to return the son after Christmas break, but refused to do so. Eventually, the father had to get a court order to have his son returned, but he did not regain custody of his son until April of 1995. The father then sued the principal for negligence and intentional interference of his custodial rights by allowing the mother to take the son. However, the court did side with the principal, stating that he made a discretionary decision and did not act malicious in his decision, therefore was protected underneath the State's Immunity Act. So, looking at how my school district would react to a situation like this is difficult because I could not find any policy or procedure for this type of incident. However, I did have a situation like this happen in my own class a few years ago, in which it was unclear whether a student was supposed to go home with the mother or father on the first day of school. So ultimately, my principal made a decision based on the writing that was in the custodial rights, much like the principal did in this case. I believe she checked with the judge before making her decision too, which helped. Which kind of leads into the proactive measures for this type of situation, which is to try and include a judge in your decision when deciding whether the child should go home with a certain parent or not. I think this is just one of those types of situation that it's hard to have a set procedure because so much of the actions that take place are dictated by what's stated on the court documents, which sometimes can be pretty wishy-washy. So I think it's just good policy to try and involve the judge who made the ruling, if possible, to help make the decision. I also think if I were the principal, I would want my superintendent involved with this just because it carries so much legal weight behind it. I do think it's safe to say that most principals in this situation would make the same judgment call as the principal in this situation did, especially with the police officer there and the court documents that were present. As far as the professional ethic benefits, I think as long as educators and administrators are using good judgment and they're not acting malicious and using good judgment, and their discretionary decisions are going to have a little bit of immunity to them just because of the difficulty of the case. So that's my presentation on tort liability. I think overall the takeaway from this is that supervision is key. If we're keeping a watchful eye on our students, then it's going to be hard to make a case against a teacher for negligence. And more importantly, we keep our students safe. Thanks for watching.